Welcome to Jones Day's Tax Practice Presents a four-part webinar series, The Four Acts of an IRS Controversy, Act 2. Our program today is being presented as a webinar. This program is scheduled to run from 12:15 p.m. to 1:15 p.m. If you are having difficulty hearing me, please check to make sure that you have the volume on your computer turned up all the way. If you have any other technical difficulties, contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you have not already downloaded a copy of the presentation materials and the CLE credit information sheet, you can do so from the Handouts tab on the left. This presentation has been approved for CLE credit for attendees. The CLE credit information sheet provides you with information regarding the available credit. Applications for CLE credit in other states will be made as needed. There are several important steps that you must take to demonstrate that you are actively participating. Each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you have not individually registered for this webinar, please do so immediately by contacting Laura Bay at lbeh@jonesday.com. At various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to 1 minute to confirm participation. If you do not confirm when the box appears, you will be denied CLE credit for the webinar. You must be logged on for the entire webinar. Otherwise, CLE credit will be denied. Within 24 hours, you will receive an email with a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory to enter your bar number. If you cannot locate your bar number, please contact the Beacon Live Help Desk for assistance. You will be in listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located on the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. I will now turn the presentation over to Chuck Hodges. Thank you.
Thank you. You know, some would say the IRS appeals process has changed over the past few years, and some would say it hasn't. And they both could be right. You could have situation one, where you've got an appeal going on, where you wrote your basic protest, you maybe supplied an additional document to appeals, exam never really asked for, and met one-on-one with an appeals officer and settled the case on an informal basis, just like you would have 5-10 years ago. On the other hand, you could be in situation two, another appeal, possibly in another town, where the appeals officer actually gets into discussing your responses or lack of responses to an acknowledgement of facts IDR from the exam, conducts a 1-hour pre-conference call in which exam is involved, and then, especially in transfer pricing, you go to the conference and there's members of the transfer pricing exam team there, ready, willing, and able to do a presentation. And then the appeals officer is there with counsel too, and the counsel actually asks, IRS counsel actually asks the VP of Tax, who is present, a few factual questions. Well, the purpose of this presentation for Jones Day is twofold. First, you know, as you would expect from us, we give you detailed materials with citations, of which we will never be able to cover all of them, as you can imagine, but giving you a good reference guide that you can download in dealing with appeals, whether it be situation one or two. But then also, you know, we're going to discuss how to prepare for situation one or two, and how you can be ready for both, because you've got to remember this is your last guaranteed opportunity to settle with the IRS before going to court. My name's Chuck Hodges. I'm a tax partner for Jones Day in the Atlanta office, and my bio is pretty easy. For 22 years I've done one thing, and that's fight the IRS, from exams to appeals to the U.S. tax court to U.S. district courts and U.S. appellate courts around the country. And we are really, really excited to also be joined with us, Ray Wiacek, who is a partner in our D.C. office. Many of you are friends of the firm and know in one sentence, Ray is just one of the world's leading international tax attorneys, both on the transactional side, handling cross-border financing, reorganization, global planning for IP, but then on the tax dispute side, representing taxpayers in tax disputes involving transfer pricing, research development, as well as challenging the IRS's anti-inversion regs in court. And lastly, we're joined by Aditya Shrivastava, who is one of our tax associates in Atlanta, or we like to refer to him as Diddy, but like P. Diddy, except more of the Jones Day version, which is instead of having his own vodka line and rap albums, he has a physics degree and deals with tax disputes. So, but we have a great group, and as you see, this is the second webinar in our four-part series of dealing with the IRS. Many of you joined us for Act 1. If you did not, and you would like to hear it again, to see it, it's actually on YouTube. You can go to Jones Day and IRS or Jones Day and 4 Acts, and you can find it there. But we are on to Act 2 now, and with Act 2. We are dealing with, the IRS Appeals Office after an unagreed exam. We're going to conduct, as you see on the slide, we're going to conduct Acts 3 and 4, 3 being alternative dispute resolution, 4 being court later this year. Diddy suggested maybe we'll do a little box set at the end for holiday gifts for our clients, because how do you tell your clients you care about them more than sending them tax webinars? But for now, we're on Act 2, and we're dealing with IRS Appeals. And so I want to kind of kick it off with Ray kind of sharing with us how he explains his views on the IRS Appeals Office to our clients.
Thanks, Chuck. My name is Ray Wiacek, and I have done a lot of stuff, including running the tax practice globally for 17 years here at Jones Day. But among the things I've done are lots and lots of appeals. Chuck asked me, have I done hundreds? No. Because hundreds with an S on it, plural, would mean that I'd have to do 5 a year for 40 years. So I've not done hundreds of appeals, but I've done lots and lots and dozens and dozens and dozens, from New York to LA, from Charlotte and Atlanta to San Francisco, Pittsburgh, Detroit, every point in between. I did an appeal in Indianapolis that lasted 3 years. I did an appeal in Des Moines, Iowa that took 3 trips. I did an appeal in Omaha in the middle of a blizzard. That was an interesting one because it will tell you something about the appeal process and why I like it. I landed in Omaha, and it was the day before, and it was snowing and blowing by that night. It was 20 below. It was really snowing, and it was blowing 50 miles per hour. It was a full-on blizzard. And the appeals officer called me at the hotel and wanted to make sure I'd gotten in safely. And whether I wanted to go on. And I said, yeah, of course I'm here now. And he said, well, let's do it. Let's start an hour and a half late. But I see where you're staying, and I'll pick you up on the way in. You don't get that in litigation. The appeals process is friendly in the main. It's flexible in the main. And it is a chance, as Chuck said, to resolve your case favorably. So I'm a big proponent of the appeals process, and let me enumerate a number of reasons why. Number one, taxpayers get great results in appeals. The IRS releases data, it's on a delayed basis, but it shows that taxpayers get 78 cents on the dollar, 83 cents on the dollar. They get a lot of money in appeals. Some of this is because exam does a bad job, but there are other reasons as well. The national office doesn't always like that. Exam hates it. Chuck mentions they're starting to provide more counsel, more experts. Exam can be there. They're trying to limit our ability to do well in appeals. But by and large, the limitations, we can handle them in stride. They're not bothersome at all. So first reason, you have a good shot at doing really well in appeals. The second reason is almost mechanical or logistical. My view is you should never pass on a turn to come to the plate. Take your at-bat. Come up there and take a couple swings. From the time the audit starts I'm looking for the person at the IRS who says, wow, client, taxpayers' facts are really pretty good here. Or, wow, Ray explained that really well. I think he's right. That's the guy you're looking for, and you get a chance for that guy to be the appeals person, and you don't want to pass on it. Reason 3, the person you're presenting this to and hoping to resolve your case with is officially charged with resolving your case. The mission of appeals is to resolve taxpayer controversies. When you go into some of the old federal buildings around the country, that mission statement is still sometimes hanging in a bad cross-stitch or embroidery on the wall, that we are here to resolve your tax case reasonably and in good faith. And they're permitted in doing that to take the hazards of litigation into account. They're permitted to settle on a percentage basis. They're frankly permitted, because of how flexible the process is, it's probably not formal, but to trade issues. There's just a lot of ways that you can reach a settlement with these people. Number 4, I would contrast that with a litigator. Of course, we've all done litigation, and in Jones Day, we do all kinds of litigation, not tax-related, and a lot of our litigators settle. But the mindset of a litigator is not necessarily to settle. And they're not officially charged with settling or resolving your case. I had an appeal on a coal matter. It ended up in trial down in West Virginia. It was a valuation case. You take the top off of a mountain of coal. In the old days, it produces a lot of flat land. You didn't have to restore the contours under the environmental acts of the time. Flat land is really, really valuable in the hollows of Virginia and West Virginia. Our client gave a couple of mountaintops away to the local church to put up a new church and parking lot, and to the YMCA to put up ballparks and soccer fields. Took an enormous charitable deduction based on the fact that one of their other mountaintops had been bought by the U.S. government to put up a post office. The appeals guy was one I couldn't settle. He just said, I don't have any engineers, I don't have any valuation people, it's just too much value, I can't do it, so we have to go to court. I thought I'd be able to settle with DOJ. We chose DOJ because we paid the tax and decided to sue for refund. If we had to litigate, we were going to do it with home cooking. We were going to do it in the Federal District Court in West Virginia, where I think the judge was the cousin of the CEO of our client. I mean, the fix was going to be in. So I talked to the DOJ guy and said, you don't need to go down there. I don't need to go down there. I don't want to charge the client a lot to prepare for a litigation. I don't want to have to hire experts. I'll give you 15 cents on the dollar. You don't even have a case. No deal. So we have to litigate the case. The case starts at 9:30. We get a judgment from the bench by 11:30. We disqualified both of his experts as not being expert in the area because we had hired the only 2 real estate people in the hollows of this part of West Virginia. I said to him afterwards, what the hell? You could have had some money. You could have saved us some money. What was this all about? And this is not always the attitude of DOJ or Chief Counsel, because obviously cases settled, but this is indicative of a litigation mentality versus an appeals officer's mentality. He said, Ray, I am a trial lawyer in the trial division of DOJ. I am charged with trying cases. I have a docket of 26 cases. Now that I've lost this one, they'll add 2 more, and I'll have 28 cases. I have a trial the day after tomorrow. I will get a lot more credit. I will be treated as a warrior for having come down here to West Virginia and tried this case, even though I lost it. I would have been treated as a chicken if I took 15 cents on the dollar. That happened early in my career and made me appreciate appeals even more. And then the next reason, I think it's number 5, is the process itself. Not only might a guy pick you up in a snowstorm, but the whole process is informal. It splits things. It looks at percentages. It looks at hazards. The person has a settlement mentality. He doesn't have a litigation, or she doesn't have a litigation mentality. The whole process is open to shaping by you. You get to grab the process. You get to help set the schedule. You get to explain your case in the way you want to. And it's just you know, to me, a place where if you have any interpersonal skills or any skills of advocacy or persuasion, and you have a decent case, and you have someone on the other side who's instructed to settle reasonably and in good faith, that you have a really good opportunity of achieving a reasonable result. And the last thing I would say is, in my experience, I've had good appeals officers. And I'd actually rather settle cases with people that are, or discuss cases, you can't always settle, with people that are intelligent and hardworking and are experienced. You don't usually get junior people in the appellate division that exercise judgment. Your best chance of resolving something that's difficult and complicated is not with somebody who's just going to play by the book and is unthinking or lazy. And in my experience, I've come across some really good appeals officers. That would, I think, take me to maybe page 9 of the slides where, because you get a bonus here. All three of us are going to talk. You get slides. We're going to tell you, we're going to email them to you after the presentation, so everybody has the slides. There are a lot of cites in the slides. In talking with you, we're not going to recite orally the cites. So you're going to get both a presentation and a free set of slides. They're complementary but not identical. But I would come to page 9 and just say, in the statement of a lot of the rules, you should just put generally, comma, in front of all of them, because none of them hold true. For example, it says that no nuisance settlements are permitted. And that's generally true, and it's pro-taxpayer, and appeals lives by that. They won't try to get 10% out of you just because it's expensive for you to continue. But they will, in fact, accept 15% at times and settle the case. And the way to do that is to say, this is not a nuisance settlement. This is a settlement where you and I together have fairly evaluated the risks, and you have a 10, 15, 20% chance of winning this case. So I'd like to offer you this money as a substantive settlement, not as a nuisance settlement. Also, since the Internal Revenue Manual itself actually talks about percentages and what might be a nuisance settlement, you don't always have to talk about percentages. You talk about the dollars of tax involved or the dollars of proposed adjustment involved. So in transfer pricing cases, where oftentimes the proposed adjustment is well into the billions and billions of dollars, a 10% concession produces a very good return for the IRS, even though it's only 10%. So in that case, you might say, I'd be willing to go as much as $100 million on this because it's $1 billion and because you really only deserve $500 million. It's very likely, because the process is very flexible, that the guy might ask for 150, but the 10% or 15% would never come on the table. You just switch from percentages to dollars because the dollars are so impressive. Penalty issues aren't traded. That's another rule. I trade them all the time. In fact, I try to get penalties off the table at the very beginning of the process. Not always successful, but many times. My view, and now that exam is often in the appeal, at least at the beginning, I say to the appeals officer in the exam, I respect exam. We've had some frustrating times together. We've had some interesting times together. These are difficult issues. I think they're not correct in their position, but I respect it and I understand how they've come to it. I think they respect our position too, although they think theirs is better. But that being the case, one real frustration I have here is if we both respect each other and we both think this issue is hard and we both think either side could win, how the hell did I get penalized? And so I'm angry. Because I'm only subject to penalty if I'm negligent or recklessly disregarded the rules or willfully misconducted myself. So I would like, before the conference starts, for you, Mr. Appeals Officer, to take penalties off the table. I don't want to hear about it. I'm going to have a hard time sitting in this room for the next 2 days across from people who secretly think I'm a fraud. I have to tell you, that works a third of the time. They're just gone. A good appeals officer might not take them off the table at the end of the day, and he might say, let's see where we are at the end of the day. But I can tell you, as I said at the beginning of this thing, I have done dozens and dozens and dozens of appeals for Fortune 500 companies. I have never suffered a penalty. And of course, you in the tax world know, penalties have other repercussions. They bounce over to the board. It's not good for us to be considered, or our clients to be considered to have recklessly disregarded the rules or something. And if you're a financial institution with fiduciary duties, there's going to be other repercussions. So you like to get penalties off the table. So I actually share the podium. I love talking, as you can tell. I will turn it back over to my colleagues.
All right. Thanks, Ray. So just real quick, we're going to get to just to kind of put some things into perspective. I mean, one, and we'll talk about this a little bit later, but at the end of an unagreed audit, the exam will either issue the statutory notice of deficiency, or they're going to issue you the 30-day letter with the RAR. I would speculate, but I would say 90% of the cases are taken on the 30-day letter. A protest is submitted, as you see there in the reg. One of the biggest purposes of this presentation is to not say this is the right way, but instead to give you a bunch of options to think about, because some of the things we're going to talk about, I'm confident in light of the feedback that we get that you may not have ever been presented with before. And one is, which we'll talk about later, which is ignoring the 30-day letter and going straight to a stat notice and making a decision. But we'll talk about that in a little bit. Another part, too, is that the jurisdiction of appeals is a lot broader than folks think. There's been some developments on one area in particular that Diddy's going to speak on, which is cases that appeals is going to handle for all of us coming up pretty soon. And I'm going to turn it over to Diddy to talk about the jurisdiction of appeals in the new BBA cases.
Yeah, thanks, Chuck. And first of all, thanks for the shout-out to my new vodka line. I appreciate the free advertising. So one of the uncommon cases that Chuck mentioned, heard by the IRS Appeals, at least for now, are the audits brought under the Bipartisan Budget Act of 2015, or BBA for short. And as I'm sure most of you know, BBA was enacted as a replacement to the pretty convoluted TEFRA procedures. Now, we won't go into the full details of the changes between BBA and the old regime of TEFRA, but generally from a 10,000-foot level, under the old regime of TEFRA, when the IRS made an adjustment to a partnership item, the IRS assessed tax liability on the individual partners. Now, under BBA, this new regime, on the other hand, when the IRS makes an adjustment to a partnership, the IRS can assess and collect the imputed underpayment from the partnership itself, not the individual partners, but the partnership itself. So this is a pretty significant change because partnerships have never before been required to pay federal tax at the partnership level. And also under BBA, this new regime, the partnership is represented by someone called the partnership representative, or the PR, instead of the TEFRA TMP that we had previously. So unlike the TMP where other partners could elect to be involved, under the new BBA rules, the partnership representative, the PR, has pretty much sole authority to bind the partnership, and other partners have no absolute right to be involved in the process. So this is a pretty significant change from the TEFRA proceedings that we're used to. And importantly, this is new territory for appeals as well. I mean, if you think about it, while BBA was enacted in 2015, it only began to apply to tax years after 2017, so basically January 1st, 2018 and beyond, meaning essentially that this past tax season was really the first year where partnerships under BBA were reported. So when we put these BBA slides into the category of uncommon cases heard by IRS appeals, we mean that, yeah, so far there have been pretty much 0 cases that have gone to appeals regarding BBA, but in the next few years, you can bet that it's going to be a focal point of any appeals review of a partnership audit. So to help appeals, in March of this year, IRS provided interim guidance to IRS appeal employees regarding these new BBA procedures. So what's in this interim guidance? Basically, one of the obvious things in this guidance is that the appeals teams who were handling TEFRA will now handle BBA cases. So this makes sense because with TEFRA essentially repealed, who better to handle partnership cases than the appeals officers who have been dealing with partnerships? Now, of course, there's some special rules with BBA regarding electing out and the statute of limitations, but the important takeaway here is that BBA is just as new to appeals as it is to taxpayers. I mean, in fact, it's probably newer to appeals officers because at least the team here at Jones Day has been learning these BBA rules ever since they were promulgated in 2015, so to advise and prepare and plan for these last tax year's returns. So basically, just be sure to know these BBA rules and the Internal Revenue Manual to make sure that appeals itself is following the BBA procedures and not TEFRA. And that's especially considering that the BBA appeals team reviewing your case is likely a former TEFRA appeals team.
All right, thanks, Diddy. One of the other areas for that appeals handles that people sometimes don't appreciate enough, and you need to know right up front. Ray was emphasizing knowing some things right up front. One is my issue that's going to appeals a coordinated issue? Because if it is, there's a chance that there is a coordinated settlement, regardless of how strong I believe my case is. But Ray, what are your thoughts on if you've got a coordinated issue and you would like to not be subject to this, what is sometimes just, hey, we'll give you a reduction of penalties no matter what you tell us, what's maybe a strategy to pursue with the coordinated cases?
So that's an interesting question, and of course there is this slide that talks about all the different ways that the national office has tried to get hold of the appeals process and provide for uniform results. Now, we all believe in the uniform application of justice, so there's something to be said for consistency when a given transaction, a given product or something is implemented across the country. But when you try to apply a uniform rule, you oftentimes grind people up that have different facts and circumstances. So what would happen, like in an appeals coordinated issue or something, is there'd be, the national office would say, all transactions involving XYZ, the only thing that can be offered by appeals is interest only, or this or that or the other thing. So something that I've employed before and is just to rename my issue. So there was a thing a few years ago called foreign tax credit generator cases. It was a cross-border tax arbitrage product that all the banks and AIG and some of the other insurance companies used, and you got kind of a double tax benefit off generating a foreign tax credit. They changed the regs, and they went after these things very heartily. And the ACI settlement was that appeals could only concede penalties, but you didn't get a credit for the foreign taxes paid. You didn't even get a deduction for the foreign taxes paid, even though you were clearly out of pocket the money. And we thought that a number of the transactions that were done, as we watched them being done, we're going to lose, and we're going to lose big time. And we did our transactions differently. And we had lots of business purpose, lots of substance, and we put in lots of capital, and we took some risks. We actually market risks, and then layered in foreign tax credit generator products into that transaction. So we're before an appeals team that has 5 appeals officers from around the country, pursuant to the ACI, trying to keep this this issue uniform, and we keep saying, but we didn't do that. We didn't do a STARS transaction. It was the worst of or the most transparent of the transactions that have since been litigated by a lot of the banks, and IRS has won all of the cases. We didn't do that. Well, but what about this? Well, we didn't do that either. Well, but what about this? No, we were at risk. We kept going on and on. Our case was different. And they said, but we're constrained by the ACI. And I said, only if we are a tax credit generator case. Why don't we call our case the real transaction with lots of business purpose and capital case, not the foreign tax credit generator case? And the appeals officers in the room said, good idea. And we were out from under the ACI, and we got 75 cents on the dollar in that case. which matched the should opinion that we had given the client in entering into the transactions. We just renamed it. Now, we threatened a lot. There was a whole bunch of other give and take, and Chuck's going to talk about going to court quickly. We otherwise said the conference is over, we're going to court, and we're going to end up being one of the first cases you litigate, and we're going to win. And you got all these bad cases behind it that you're going to win, but we're going to be first out of the box, and you don't want, I mean, there were other elements. But this is a shtick or that's pretty informal, but a thought that I'll have across this line is that the world doesn't run in accordance with the office rule book. Appeals is a very flexible process. The national office puts lots of rules on them. You can still play ball. You can still kind of work it out with a person that is motivated and instructed to settle your case. And one thought, when I say that, I've lost appeals too, and we have bad cases in appeals too. I respect the other side. I don't think that we get stuff from them that we shouldn't. And maybe that's why they pick me up, in snowstorms or something, because, it is a matter of interpersonal advocacy and so on. I think they do a good job, and that backs up my thought that I'm a big proponent of appeals.
Okay. All right. So if you want to know, especially if you know you're in some type of transaction that could be coordinated, you can go on the IRS website. They actually list those cases that they consider to be coordinated, and actually sometimes you can even find what the settlement terms are, and so then you can spend your time and energy, as Ray discussed, trying to get it out from that. We're going to try to get through some of these other things a lot quicker, but one, just quickly, all of you on here deal some way, somehow need to with competent authority, and so the thing that I just wanted to mention is really more of the thing that people get kind of caught up on, and that is if you've got a competent authority issue, you see the mutual agreement procedure and tax treaties grant taxpayers the right to request competent authority assistance. But as you see down, the only two IRS offices which can present one of these actions for administrative review of competent authority is Appeals and U.S. Competent Authority. The thing you want to pay attention to, so of course you're dealing with potentially a transfer pricing issue, a permanent establishment issue, something where there could be double taxation. You need to realize that if you're taking this to Appeals, but you haven't been to Competent Authority is going to decline assistance unless you sever the issue from your protest. So think about it. You're at the exam. You've got multiple issues. You've got to make sure you sever it. Notice the quick timeline. So you've got to be aware of this. You've got to sever that issue within 60 days of the opening conference. So it's just something to make sure that with our clients and how many of you deal with this, that you sever it and have that timeline down. So now one of the things that is the biggest change, but I believe is the Appeals, Judicial, and Culture Project, and Diddy's going to go over that. The reason why I believe it's a change, but something we need guidance on, there's a lot of talk about the advantages and disadvantages of the project. We want to talk just briefly on summarizing what this new Appeals, Judicial, and Culture Project is, but then we're going to focus on how you deal with it, how you use it to your advantage, or how do you make sure that it doesn't trip you up. So Diddy's first going to explain.
Can I just say something about competent authority? It just occurred to me, it's an aside, but we have our presentation on taxpayer disputes in 4 acts. Yeah. And I think it's you who said most Shakespearean plays have 5 acts.
Yeah.
Competent authority is a world of its own, and it's complicated. But if you have an international issue involving a treaty where you could use competent authority, it's important. Maybe we could make that Act 5.
That very well could be.
And pick up more than 2 slides on competent authority.
Which would add to our box set for the holiday season. All right.
And your vodka set.
Exactly. All right. So again, these are rules that, and again, that the Appeals and Judicial and Culture Project, and Diddy's going to kind of summarize this, which again, appeals officers have been trained on, and it is making them appreciate this project and how they are supposed to implement the appeals process. So Diddy.
So yeah, the Appeals, Judicial, and Culture Project, or AJAC project, it became effective for cases received by IRS Appeals after September 2014. And essentially, the focus of AJAC is to ensure appeals has rules in place that prevent appeals personnel from essentially acting like an extension of IRS exam. So one of the central tenets in this is that appeals officers should focus on their core mission of fair and impartial decision-making free from influence. So essentially, AJAC wants appeals to act in this quasi-judicial manner. And this is a theme you will see throughout today's presentation, that the IRS wants appeals to be treated almost like an administrative law judge, kind of like what Ray was saying earlier, this independent arbiter. So appeals officers should not be investigators or examiners. Instead, they're supposed to act like an ALJ. So accordingly, this role acting as a quasi-ALJ has two functions. The first, to make sure that the appeals officer has independence, and the second, to make sure that the appeals officer has a fully developed list of issues in front of him and her to make this reasoned decision. So what happens when the issues are not fully developed? Well, generally, appeals settles undeveloped cases, as Ray was mentioning. But here's important to note that undeveloped does not mean that the taxpayer or exam can raise a huge pertinent fact at the last minute. If the taxpayer submits new information for the first time during appeal likely will send the case back or remand to exam if it believes the new information should be further investigated or developed by exam. However, if appeals believes that the new information that has come forward does not require any further analysis or investigation by exam, then appeals can keep the case, or keep jurisdiction, as they call it, and simply give exam an opportunity to review and comment on the new information. Now, one of the most important points about AJAC is that neither exam nor appeals can raise new issues for the first time during the appeals process. So this is a big point, because it means that if no new issue is raised, then appeals cannot remand the case. They have exclusive jurisdiction of it. So one way or another, it will come to a decision. Now, a taxpayer can raise for the first time in appeals any new legal authority or legal arguments regarding any issues. So if you have a new case or new citation or legal argument about a specific citation you want to raise, you can do so without fear of appeals remanding it back to exam. And of course, as you see in the last bullet point, taxpayers may raise any new issues when reviewing a statutory notice of a deficiency.
Okay. Great, Diddy. All right, so now here are, we're on slide 24, and now we're telling you how to prepare for the appeal.
Do you want me, because I have a thought also
Sure.
on Diddy's thing, is that it's two-sided, because I think they've always acted impartially and as an informal administrative law judge, but within the project is also to get them more help. And so, again, it's the national office. On the one hand, they're supposed to be fair. I always thought they were fair. They're supposed to give you a de novo hearing. I think they were doing that anyway. But so the other parts of the project is they have more help. And as part of the project, exam can attend. You'll find counsel there. They can get counsel. They can get experts and so on. So there's a sense in which the project has caused the appeals process to be more professional in that sense. That hasn't bothered me at all. I know at a lot of ABA meetings and that people think, gee, now the lawyers are there, and before you just had a judge and without lawyers. But if you think about it, what an advantage. We got to show up, the client showed up with lawyers before the appeals officer who had no help. And so, all right, it's a little harder now. Now the appeals officer can have counsel if he wants. That's okay. If you litigate it, you'd have counsel there. I mean, to me, all this project has done is been evolutionary. It's not been revolutionary in any way. You adjust to the new landscape. I've never minded exam being there. Exam, you already know, is wrong. All you're looking for is a fair and intelligent hearing. Almost no one on the phone does transactions that they know are bad, right? That's not what we do in the tax field or the tax practice. Most of us don't even like doing more likely transactions. We like doing should transactions. So you go into any kind of thing, no matter how many people they have on the other side, thinking, I'm right, I just need someone that understands.
Yep.
All right, they show up with more people. Then you got a better chance. Now you got a lawyer who might hear you, you got an engineer who might hear you, and there have been appeals officers who've just backed to the field, in my experience. You know, not very many. That's why exam hates appeals. Appeals does give the taxpayer a fair hearing. So anyhow.
Okay. No, that's absolutely true. And that's just it. That's one of the purposes of this presentation, is to just help you, deal with the new rules to what extent that they are applied. Just like I mentioned at the beginning, situation 1 or 2, the purpose of this is to help you deal with either situation. But, how to prepare for the appeal. The one thing which, again, hope for those of you who attended the first one, we spent a lot of time on the exam, and one of the main things that we emphasize with this proactive approach to your exam. I will tell you, a lot of times when I get the case that's going to appeals, I hear a lot of the things of we are right, and then I review, for example, the IDR responses, and I don't see the storyline, or so you have a transfer pricing case, you have whatever issue you have, where is the storyline versus just responding to the IDRs? So what we're saying here on this preparation for appeal, the first one is, you don't wait till you get your actual final NOPA and then say, all right, let's have a meeting about how to do appeals. Why is that? Diddy mentioned it. You can't provide new information under these rules. You're not supposed to without it getting remanded. So you got to make sure at the end of the exam, I know I've got an unagreed issue. I've got their draft NOPA. I see where they're going with it. Have I now shared all of the things that I need to share that I'm going to want to share with appeals? Have already shared it with exam. And so then, too, now I need to look at my IDR responses closely. I was answering the IRS examiner's questions. Have I really ensured that my message is there? Because, again, the appeals officer is going to review those. Do I need to supplement them? Always remember, there is no statutory authority for you to respond to IDR responses. So, you only summonses, and those are not self-executing. So look at your IDR responses. Look and see, do I need to supplement these? And again, this is all to make it to where you're not raising any new information or raising new issues at appeals. Then lastly, one thing I get asked a lot is, Chuck, I got 5 issues that are going. When do I concede some at the exam level, and do I just take the one issue that's really in dispute to appeals? I generally like it where it's going to be one tax determination. That way you get one tax bill, you get one write-up, and you settle everything with appeals. But that can be a case-by-case basis. And then the last one, which we're going to get into, hopefully you can listen to the first one, one of the new game-changing rules is this acknowledgement of facts IDR. I will say that if I talked to 10 tax controversy attorneys, 9 of them will tell me that they ignore it when they know they're going to appeals. That could be the right answer in a lot of cases. But once again, purpose of this presentation is to make you think too, well, what is the other side, just in case there is. So that's how you prepare for appeal when you're getting towards the end of an exam. And that's what this acknowledgement of facts IDR is. And we talked a lot about in the first one, so I'm just going to try to summarize it. And what it is this is an IDR at the end of an unagreed exam where the examiners say, here are the facts and maybe mixed facts of fact and law that we believe are right. They're in our report. Please tell us that you agree. Well, most just ignore it because this is one IDR that cannot be enforced by summons. The thing is that I believe exam misses the purpose of the AOF IDR, and I want to make sure that I think if taxpayers appreciated what the actual purpose was, then they would utilize it. Why do I think this is important? It's for the end of the presentation where we talk about the conference. You're sitting across from the examiners that maybe you had a hotly contested examination with. You would like to be able that when a factual issue comes up, you would like to be able to say, well, the parties have already agreed that that fact is X. And then when exam goes, well, I don't know if we agree with that. Well, we did agree with it in the AOF IDR and the responses. So what I kind of point out here is this is the AOF IDR language, actually straight from the manual. Notice how the IRS manual doesn't say this is to ensure that the IRS's relevant facts are in there. It actually says no, it's all relevant facts. And so the whole purpose of the AOF-IDR is to ensure that appeals has a fully developed case and as many agreed upon facts as possible. And I think this will help the situation to the conference. And so, a couple of points I want to make. One, sometimes folks examiners will give the AOF-IDR out before they give the proposed NOPA. No. You need to see the proposed NOPA. You need to see what elements am I having to deal with before I agree. But then when you respond, you say, and this happened to me recently, the proposed NOPA said that the taxpayers pointed out these 10 facts. We don't believe they're relevant. Great. Let's go ahead and agree to them. You might be right, but go ahead and agree to them in the AOF-IDR responses. That way when we get to appeals, maybe you're right. They're not relevant, but at least we'll agree to them, and then I can present them. For the litigators on here, you'll appreciate, and that's why I want to finish this one up kind of quickly, this is exactly what the tax court makes you do. Tax Court Rule 91 says, parties, you got to get together, and you make sure that if there's factual matters or even mixed matters of fact and law that you agree to, put them into a stipulation so I don't have to hear all of these issues. So we would highly recommend in some cases that you do what you can to get the AOF-IDR response to a point where you agree with the relevant facts and the IRS agrees with the relevant facts to minimize the disputes, because we know what happens when folks get together in that conference and then all of a sudden maybe tempers start going up. You want to be able to point to a document that says, sorry, this fact has already been established, and that will allow the appeals officer to move on from that fact and say, you know what, exam, you did agree to it. And also, which is really important, which has happened to me in my last big conference, is all of a sudden new issues popped up. So I make sure that in my AOF-IDR responses that I also get the parties to agree what issues are actually in dispute, because you don't want new issues to pop up in the conference. So again, another way to look at that. The next part that I'm going to skip to is, again, not a, hey, this works in every case, but something to think about, and it may be something that I bet many of you have never even heard the option of, and that is, how do I get to appeals? Because I've only ever heard that I get my 30-day note, I get my 30-day letter, I file a protest, but think about it for a second. You get a very incomplete exam. You get a 30-day letter. They know that they're going to get a rebuttal to your protest. And so therefore they can deal with anything that you raise. They can continue to develop the case. But let's say that the presentation is really, really bad. The case is really undeveloped. And they get the chance to fix it. Well, you may want to consider then saying at the end of the 30 days, I've decided to bypass this route to appeals. I still want to go to appeals, but I've decided to bypass it. Please send me my statutory notice of deficiency. And then that's exactly what the IRS has to do, and now the examiner's undeveloped case now becomes an undeveloped statutory notice of deficiency, which locks the government into that position. That is not the thing to do in every case, but just think about it in certain ones. So why would you decide, and once you then get your notice of deficiency, you have 90 days to file a petition in tax court, where over 90% of all the cases docketed in tax court are settled. But you get your notice of deficiency, you file your petition, you then get to go to appeals, which is what we talk about, in the appeals process here, which is, as you see on the one bullet, after the filing of petition, appeals generally has exclusive jurisdiction to settle the case for 4 months, not 4 years like we have in a lot of appeals cases. So you want to consider this option. Now, again, I try to think of the elements on deciding, do I go protest or do I go petition and then go to appeals? These are some things to think about. The desire to complete the administrative process. Maybe there are just some reasons why you need to get off of the IRS's field. It is their playing field. I need to get off of it. But 2, though, is another one, which would be the contrary one. I got to avoid litigation at all costs. And then 3, how well developed is the notice of deficiency? And then, of course, on 4, once you have a case petitioned in tax court, counsel gets involved with appeals to get it settled, and maybe will actually assist in showing the actual hazards of litigation. And so then lastly, you may want to stick with the protest route because you want to develop your case further. So those are some thoughts to think about between the two. Real quick, this has been happening to me more recently where the IRS needs up to a year, as like Diddy was pointing out in the BBA, a year on the statute. And so the IRS will say, exam will say, I need a statute extension if you want to go to appeals. Yes. But what I've noticed, and it happened to me in one case, was gave the statute extension. Next thing I know, the exam continues. And I'm like, well, it was my understanding we were getting the statute extension to go to appeals. And so now what I've ensured is that I make sure that the examiner knows I'm giving this statute extension because we're done, and appeals needs this extra year, so I'm only giving it to you to where now it can be transferred to appeals. So make sure that the taxpayers confirm in writing that you're giving a statute extension only to allow appeals the amount of time they've asked for. Again, here going to appeals in a docketed case, as I mentioned too, these are the rights that are set forth in the Rev Proc. And again, you want to look at these. When does it make sense to go to appeals after you've docketed in tax court? The next one, which we're going to go to just briefly, are things that no substantive rights come from it, but a lot of people have questions. I get probably a call a month on, hey, Chuck, the IRS appeals violated ex parte communications. What do I do? So Diddy's going to quickly summarize what exactly is the prohibition on ex parte communications and how to deal with it.
Yeah, thanks, Chuck. And I know we're short for time, so I'll be brief about these next 3 slides regarding ex parte communications. So basically, if we're trying to get appeals to act in this quasi-judicial function, and as they've been doing for the past however many years, and essentially as this ALJ, there needs to be some kind of guarantee against improper communications between appeals and exam. So this is the ex parte communication rules. Now, according to revenue procedures and the Internal Revenue Manual, appeals cannot have conversations or communications with the exam beyond ministerial discussions. So that's things like the status of the case, calculation questions, database inquiries, caseload, things like that. So meaning appeals cannot talk to exam about truly substantive matters, things like credibility of the taxpayer or credibility of the taxpayer's position. Now, the next few slides have examples of communications that are accepted and communications that are prohibited. But instead of going through them all individually, the general rule of thumb here, and any litigators in this webinar will appreciate this, is to look at ex parte communications as if you are in that court setting. And instead of a judge sitting up there, there's an appeals officer, and think, does this communication seem okay? Is there something off or untoward about the communications between the judge and the plaintiff, one of the parties? So I'll give you an example. We recently had a case where we found out that the appeals officer made a determination based at least partially on analysis that exam had sent directly to appeals. Now, if you're looking at this without your litigation lenses on, you may think, okay, exam is just supplying more information to appeals. What's wrong with that? Hey, appeals asked exam for this information. But the problem that we pointed out immediately, and I'd like to think to great effect, is that when exam gave documentation directly to appeals, we, the taxpayers, never got a chance to review the document, respond to it, and that breaks these ex parte rules. So if appeals is really to be treated like this quasi-judicial function as the IRS demands, then appeals, aka the judge, can't communicate substantively with one side and not involve the other. So what I'm saying is that even though you may find yourself in the appeals process, and even though we know it's not a true tax court or other federal court proceeding, it's still beneficial to sometimes have a litigation hat on so you can kind of catch these inequities and ultimately use them to your advantage.
Okay. All right. Thanks, Diddy. All right. Now we're going to turn it over to Ray to talk about kind of the protest and the non-docketed case and the things that you want to kind of think about as you're preparing your protest, which, as Ray pointed out, is an advocacy. I mean, it is. It's a brief. So,
well, first I'd like to comment just on the ex parte rules that Diddy just talked about. And it's been mentioned several times that exam unlike back in the day, is now entitled to appear in the first appeals conference and participate. And sometimes that's described as the ex parte presentation, because it's not ex parte because you're there. So it's misnamed. And there's a lot of discussion and strategy that goes into whether you want to kick them out afterwards or whether you want to continue and let them participate. And I think that is a little bit like Chuck's tactic of sometimes going right to tax court because the field exam is unprepared, which is a tactic. It's one Chuck likes and has worked for him. It's one I've not liked and hasn't worked for me because I don't have that many audits where that when the field is done, the case is unprepared. I have really big clients. The things get audited for a hell of a long time, and exams often wrong, but they're not unprepared. So what that really shows, and we haven't said it, is we keep. I did say it. Almost everything we should say should be started with generally, comma, because all decisions on appeals, litigation, tactics, strategy are heavily fact-dependent, law-dependent. They're dependent on things like how many unagreed issues do you have? Is it a carryover issue? Did they miss the biggest issue in your return? So you're in a hurry to clear the thing up. You don't even want to extend the statute. There's a whole bunch of considerations. For me, I often let the exam team stay because I think we're better than them. And I like to show the appeals officer why we have unagreed issues and what we've been up against. So if you have an exam team that is going to be cranky and argumentative and unprofessional, let them stay. If you have an exam team or an economist, oftentimes in transfer pricing cases, I have to say the IRS economists are often very poor, you want them to stay. You want them to make a presentation, and then you want to, in front of them, perhaps say to the appeals officer, now you know why we're here. And I often let the appeals officer say, well, why don't we let them go back to the office? And then I don't have to kick them out. That's also a good strategy for the future because you often have the same exam team in the next audit and maybe a third. You might even be in that appeals conference with that exam team for the second time. So they want to stay. I'm most of the time happy with them staying. All right, so you get the 30-day letter. You've decided what you're going to do with the AOF IDR. You've put all the facts on the table that you need to put on the table. You should start writing the protest well before you get the 30-day letter and when you get an RAR or anything else. The one thing I would say, somewhere in here there's a slide that you can present charts, you can be creative. You know my whole presentation has been flexible and creativity. The protest, you have to file one. It has to be written. There are rules and so on. We won one really big case where the protest was a 15-foot long piece of rolled paper tablecloth, where our client had been involved in a highly contested takeover, three-way. The target had signed a contract to be taken over by somebody else. We blew that contract up. A lot of litigation in Delaware and everybody's home state. In any event, it resulted in the payment of a breakup fee of well over $1 billion. We paid that just before the regulations came out that said breakup fees are capitalized to the cost of purchase and aren't deductible. So we deducted the whole thing because the reg was prospective, and the reg, it was probably not wrong because they had the authority to issue it, but it was wrong under all prior law. So we argued facts and policy and everything else and not the reg. We said the reg missed us by a couple days. And they got into it. Appeals accepted, and they started arguing with us the facts as to whether it was more like a capital cost or an ordinary cost. So we did this presentation on a rolled out kind of piece of white paper that you'd put like on a picnic table, where all the facts that were in our favor were in green, and all the facts that would support their argument were in red. And of course, the paper wasn't the tablecloth wasn't going to be all Green, who's had such a case where everything is in their favor. And we came to the appeals conference, and we started at one end of the table, and we rolled it off. And it went off the other end, and it went on the floor, and it rolled a couple feet. And we said, that's important. That's important. You better get down there on your knees on the far end where it's rolled off, because that's your case. That's all you got. And we won that case, or we settled for a really good number. It got me kicked out of IRS Appeals in New York for a couple of years because we were 100% reserved, and it was a really big number, and it was we settled just before our Q was filed, so we had to release the reserve and run it to earnings, and it made the front page of the Wall Street Journal. And the appeals officer called me back the next day and said, you were 100% reserved? Don't come back here for several years. So the idea is the protest can take many forms and many shapes. Let me kick it back for closing remarks.
Okay, we just have, it looks like just 5 or 6 minutes left, and so I'm going to try to just hit some of the last highlights. I mean, I think that with protests, the one thing, how can you help the appeals officer? Appeals officers are slammed. We all know what the constraints on their time. So when you're preparing a protest that is supposed to be a persuasive, if you don't think it's supposed to be persuasive, look at what the ACM, which is the appeals case memo. This is what has always guided me. I have to know what's the appeals officer have to prepare at the end of the case to send to his or her manager to prove that our case is right. And as you see here on slide 42, this is what the ACM, or appeals case memo, contains 4 parts. Why would you not write your protest in a way that allows the appeals officer to almost copy and paste what you wrote, and you write it in this way? So look at the ACM, look at the contents, and as you see here, we've incorporated all the things that are in the ACM, so please write up your protest in that way. The next thing that last 2 things I want to hit on, one we've talked about a lot, but these pre-conference calls. So now let's assume you're in situation 2 that I mentioned at the beginning, where it's a full-blown transfer pricing appeals matter, and the appeals says we're going to have a conference call before we have our big conference. And the next thing you know, I want to tell you guys, when you're talking about the pre-planning conference call and appeals, having exam attend these meetings, how does the IRS transfer pricing group think about this issue? Well, look at what is in the transfer pricing, the new examination plan. This is straight from, the slide 52 is straight from the IRS's transfer pricing plan. Notice how they say, as exams issue team will begin preparing the pre-appeals presentation immediately after closing the case. Request a pre-appeals conference. Contact the appeals officer and request examination's presence at the taxpayer's portion of the presentation, and hold mock presentations. So they are definitely taking these issues seriously on letting us attend, we the IRS attend the conference, as well as the pre-conference call. So what do you want to do on the conference call? And I'm sorry that we kind of jump around here a little bit, but it's invaluable. But on the conference call, you want to make sure the rules are set out. And what do you mean by the rules? You want to know who's going to be in attendance, and then how is appeals going to conduct the conference? Can we do opening statements? Are there going to be presentations? Is there going to be rebuttal? You want to make sure you go over all of that, and if the VP of tax or somebody from the taxpayer is going to be present there, you want them to know it too. Now we get to the appeals conference, which is our last point, and it's an important one. We all know this has been, somewhat, it's been discussed a lot, the advantages and disadvantages of appeals implementing this initiative to absolutely have exam and counsel in these conferences. The purpose of this presentation is we got to deal with it. We got to embrace it, so what do we do? And so here, the thing is that you can look at all the reasons why appeals says it's good. It's going to help you to improve efficiency, resolve the case sooner, and so on and so forth. But really, you've got to plan for it. And so now, how do you plan for it? And this is what we have here. The way to plan for it is, 1, do not ignore the acknowledgement of facts IDR, as we mentioned. Utilize it to reduce disputed issues. So if you know you're going to have a room full of IRS examiners and counsel, how can you make it to where there are less? Because I have been in a conference where we got so tied up in disputed facts that we spent 3 or 4 hours on that. The AOF IDR could help. Next, you want to look at, you're going into a room full of folks, IRS lawyers, IRS examiners, and so you need to have someone on the taxpayer's side that has some form of mediation litigation skills, and especially when you look at whether the exam was contentious. And then know that the IRS in these conferences has been asking the taxpayer, exam as well as counsel has been asking the taxpayer's representative questions. So you need to be ready for that. Lastly, which we just did yesterday, do a mock conference where you have somebody that's the appeals officer, you have somebody that's exam, and you kind of go through it to see how to make the conference the most effective. We literally changed our entire slide presentation based on our mock presentation yesterday. And so, last point. At this conference, bring your decision maker unless you shouldn't. Who shouldn't? The person who was intimately involved with the transaction, who maybe is not comfortable getting asked questions about, hey, because think about what question could be asked. Why aren't you taking our 25% settlement, taxpayer? That can be asked. So is the right person there? Make your opening statements. Invite response by exam to your opening statement so you know what to address from then on. Listen to exam. I had 2 new issues raised in my last conference, and I pointed it out to the appeals officer that these were 2 new issues, and they, of course, said we're not addressing those exam. Bring all your relevant documents at issue. Instead of just saying in your file is, actually have them there. And then, as I mentioned, once you're done, prepare a summary after the conference to appeals to confirm all the things that were addressed. Whether or not you want to bring your expert is another issue that you want to think about if it's going to be helpful.
So do you bring your decision maker? Because I would say in most cases no, or I'd bring my mini decision maker. I'd bring my VP tax. I'd never bring my CFO.
Yeah, you would.
And the answer to why wouldn't you accept my 25% settlement offer is because it's laughable.
Yeah,
as we've been telling you for the last 2 years.
Yeah.
So you need someone who, at lunchtime, is the person in the client that you're working most with, who can say, let's do that, or let's not argue that any further. I think they're right on issue 3 since they gave us issue 1 and 2. Let's concentrate on issue 5. You need that kind of decision maker, but I would always hold in reserve, we've got to take this to the board or we've got to go back. And if you're running out of time or they're saying no or the time pressure is there, you can always have the guy on standby, not in the room, somewhere back at the client. At least that I don't know what your experience is.
Yeah, no, and that's just it. You need to make sure that the person who does want to attend, who is, especially 5 years ago, who was used to sitting there with just, counsel, his attorney and the appeals officer and was very comfortable in that situation. It's a whole different game like we did in our mock presentation yesterday where all of a sudden it is, hey, can you explain what happened here? Why was it reported this way? And the detailed questions. And the person who our client looked at it and said, you know what, I'm not prepared to get into those questions. And so just know that you need to have the mock presentation. Transfer pricing group out of exam is definitely doing it, so you need to do it too and see who should be in the room. But anyway, so
don't you think, as a citizen, not as a taxpayer representative, all the new processes are in a way fair? Because before we had a quasi-judicial process, we had a fair hearing, and we showed up, client and lawyer. Client was all lawyered up. Appeals officer was by himself. Maybe that's why we did so well for so many years. It doesn't bother me as a citizen and as a taxpayer representative. It's just something that we have to confront, that the national office has now said maybe appeals should hear the case from exam, not just in writing but orally, the same way they hear the case from the taxpayer orally. And maybe appeals should have lawyers because client has lawyers. That's just the new reality. Yeah. And you're exactly right. Deal with it, understand it, know that they're there, know who the opposition is on the other side. I still think, since most of us don't do deals that are really bad, and most of the issues when you go into them thinking ambiguous at worst, but we're right. Yeah. We maybe should write or whatever, but I still go into all these meetings with all these people thinking, all right, now there's 5 people on the other side of the table instead of just one who might say what I said was our original objective. Find a guy in the IRS on the other side of the table, whether it's an exam or elsewhere, who's going to say, I think their facts are pretty good.
Yeah.
Or I think this has been explained very well by counsel. They may be right.
Yeah.
So I kind of look on the bright side until the other side shows me not, you know, because
Yeah.
we all have had that guy, as you say,
Yeah.
near the end it can get very angry. And so if you got a guy that you might describe as a butthead on the other side, then it's pretty easy to show fire. You can get hard really quick, right? If the other side wants a bar fight, you can show that this is not the nose God gave you, and the cut down the middle of it, as you can see on my face, was not how I was born.
Yeah.
But until that process started, I'm still in the make love, not war kind of camp. You go to court so often, you got a little bit more of the
Well, it's a
the feist in you.
On
So
that,
it's
well, on
case by
that,
case.
it is, and so that's why I think the pre-conference call is so important, because what I say is, appeals, if we're going to have these rules and you're going to let counsel there and you're going to let in this very informal meeting where it's not court, but you're going to make it look like court, make it look like mediation. For anybody who's been to mediation, you know the mediator will immediately say, wait a minute, that's not an issue that's before me. That's not. And so I just want to make sure that when you guys get on that pre-conference call, you say, okay, appeals officer, here are the 3 issues you're going to be discussing. Can we not all agree that if either party raises number 4, that is to be tabled and not handled in this conference? Here, you know what we agree to on facts. And so just make sure that the ground rules are laid out to where, you know, then that way it can be effective. All right, we just have about 30 seconds left. I just wanted to hit the summary. Just by the way, and if something happens, everybody who is attending is a friend or family of the firm, so please email us with any questions that you have, and so because we can address them, because there was a lot here. But this is the summary. 1, complete the unagreed exam with appeals process in mind. Don't wait till you get your actual final NOPA and then say, how do we deal with appeals? 2, decide at the end of exam when and how to go to appeals. One size does not fit all cases. Just make sure you talk about what are my options. And one of those options could be alternative dispute resolution, which is Act 3 that we'll talk about later in a few months. 3rd, structure the appeal in light of the AJAC project. You don't know if you're going to be in Situation 1 or Situation 2, so be ready for it. Make sure, for example, that you get all the documents and all the information you're going to need for appeals. Get it in by the time you file a protest. Otherwise, you could find yourself being remanded. 4th, prepare the protest or letter brief with the ACM in mind. Write it the way that they write theirs to agree with you. Lastly, proactively plan for the opening conference. So thank you guys so much. Hopefully you got something out of this. You got great materials, and ask us if you have any questions. But with that, Jenny, I'll turn it back over to you.
Really good, Chuck. Thanks for that. That was good. That summary was spot on.
Thank you for that excellent presentation. As our speaker said, if you have any questions, you may email them, questions related to the topic discussed today. You may email them after this event. Their contact information can be found in your program materials. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. Thank you for your time and have a great day.